Hello friends, this is P.R. Krishnan. Welcome to the 7th edition of the RERA My Perspective. In this video we will be looking at adherence to sanction plans, title defects, offences and penalties. Again, important to know what constitutes offences and what the consequences are, how to adhere to sanction plans. We shall look at all this in this video. So let us go to the topic now. I am retouching some of the points that are important and taking you all through. Adherence to sanction plans. Once you sign the agreement, builder cannot change plan, whether to your flat or the building or project, even amenities he cannot do anything. We need to be very clear in mind, he cannot change because you have signed the agreement and he has agreed to. So any change will need 2/3 allottee's written permission, which is also discussed on, this has been discussed under compensation also. 2/3 means if it is any external, if it is his own flat, then he has to take your written permission. If it is outside, he has to take 2/3 written permission from all the allottees. Builder cannot change as per his wish after plans, layout, specifications, etc. Amenities or fixtures and fittings which he has shown to you, common areas are approved and allottees have been disclosed, and they have, based on that, they have decided by. So he has shown you everything, and then you are signing it. So once it is signed, it is sacrosanct, he cannot change that. Whatever he has shown. Clear? Within flat, he cannot change, no change is permitted except minor changes due to structural or architectural requirements. So that can be minor changes, not major. Okay. 2/3 allottees written consent required to make any change in plan, specification, layout or anything. He has, this has to be submitted to RERA also and obtain their clearances before changing. This is basically for outside your flat. Anything, even the building structure, staircase or amenities, whatever you call, if there needs to be changes, then he has to take 2/3 allottees permission, and then only he can change. Okay. Now let's look at the others one. It says one of it says a structural defect. He has to rectify within a period of 5 years. Yes, within a period of 5 years, if there is any structural defect to your flat, he has to, you have to give him a written complaint, and he has to come and do it within 30 days, correct it within 30 days. Now you have sold it to somebody, that somebody can also ask the builder to do it. It is his responsibility is with the flat, not with the individual owners. So his responsibility is to ensure for 5 years nothing happens. Clear? If project has many towers under one project name, let's say tower A, B, C, D, E, F, and it's all called XYZ tower. Okay, and it is all in one name. So if he has to do any change in any one building, let's say he has to reduce a staircase, or let's say somebody has to remove a balcony, he has to take the concurrence of all the 2/3 members of all the projects. That is why what is happening now is builders are separately registering each project. Then what happens? Then they have to take 2/3 concurrence of only that project, not all. Okay. Then he can also give different dates for different projects in that case. All right. Now title defect. Title defect, again this is very important, so I would like to reiterate on this. Builder's liability is lifelong if there is a title defect. Structural, you know, for 5 years, I said, even the if you buy and sell, the other guy also can also claim it from the builder. But title is permanent, lifelong. So if there is any title problem, then you can claim, or whoever is a successor can claim with the builder, and he can get compensation, interest and full refund. Okay. There is no time limit. The builder generally for this purpose has to give an affidavit that there is no title defect, and he has to take a insurance cover also for this, supposed to be. Okay, so that's on this. Offences and penalties. Chapter 8 deals with offences. This is an important chapter. Penalties and adjudications. Okay, it deals with offences, penalties and adjudication. It lists all the penalties for each type of offences that are committed and where there is a repeat offence. Okay. Now section 59, 60, 61 are important because it goes one by one. selling without registering. So that is section 3, they are supposed to register, they have been told without registering they can't sell, section 3. Section 4 says what are documents you need to give and the truthfulness of the documents. So section 59 is section 3 equivalent, section 60 is equivalent to section 4. Now what happens in section 59, selling without registering, he contravenes any part of section 3, that's prior registration of a real project, and first time he gets a warning letter, then 10% of the project cost as fine is imposed on him, and if he continues to disregard, then there is a jail term for 3 years plus an additional 10%. Okay. Now let's go to the next section, section 60 to section 4, which is basically documentation. If he has registered with false documents or details, section 4, application for registration of real estate project enclosing documents and affidavit, he shall be fined 5% of the project cost. Okay. And now if he has violated not section 3, not section 4, but any other section that comes under 61, section 61, he shall be fined 5% of the project cost. Clear? Section 63 and 64 are a little different. Section 63 is if any direction of the order of authority is disregarded, then again he shall be fined 5% of the project cost. Suppose authority, that is authority means lower court or the adjudicating officer, they say you pay a compensation of let's say 4 lakhs to the person, or he says that you don't do this part, don't do this change, but then he does it, he disregards that, then he'll be fined 5%. Now 64 is on a higher court. If after lower court then you go to the higher court, that is member authority and adjudicating officer, you are dissatisfied and you go to a higher court, and the higher court similarly says direct something and you disregard, then 64 is applicable. Here the cost is 10% of the project cost. Let's look at more. Okay, 67, 68. Likewise, there are penalties for allottees too. Now till now we have seen the 5 parts of developer penalties. So section 3 के लिए section 58, 59, 60 or okay, and yeah, we saw is 59, 60 and 61. We saw 59, 60 and 61, and 63 and 64 was for lower court and upper court disregard. Now 67, 68 is meant for allottees. Likewise, there are penalties for allottees too. Under 67, allottee can be fined up to 5% of the flat cost if he continues to default. Similarly, under section 68, if he fails or contravenes any of the orders of the appellate tribunal, then he can be fined on a daily basis, but maximum 10% of the flat cost, or a jail term of 1 year. 69. Under this section, in case of companies, those who are responsible for the commitment of the default will be liable. However, if they have acted on behalf of others, say they are seniors or directors, then such person will be held liable, including the directors of the company. What it says here, it's very much relevant to that fund management, that way today. So if any officer of the company is responsible and due to him there is a default, that person will be responsible. But if he has committed a default on the saying of his superiors, then the superior is liable. So for instance, if in the fund management the architect is supposed to certify how much of work has been done, let's say 1 floor is done, then the engineer certifies how much brick, sand, etc. has been used, okay, or cement has been used, then the CA certifies what is the valuation of this, okay. Each of them are responsible for the action. Basis of action, only bank is releasing the funds, control part of it. So under 69 they all will come. Okay, there is a misconception among builders. See, earlier initially the thought process was they were very scared builders. They thought if the allottee files complaint, they were scared that they will be jailed or police can harass them, etc. So for them this is a good point. The answer is no. No one can file a criminal complaint or file any complaint with police. Police cannot also register any complaint for the allottees or from the allottees or from the builder. Both cannot lodge a complaint with the police. Only RERA can ask police to take cognizance and lodge a complaint. So you have to approach RERA, they have to approach RERA if they have to lodge a complaint. If allottees have issues, he has to approach a RERA. Similarly with builder. Section 81. Also, no court can take cognizance of any offences punishable under this Act or the rules or regulation made thereunder. Only basis RERA complaint in writing. Higher courts can take cognizance of any matter. Okay. Section 82. No court inferior to that of Metropolitan Magistrate or the first class shall try any offence punishable under this Act. Also, Section 79. Also, bar of jurisdiction is defined in Section 79. Here, even civil court cannot proceed with RERA authority. So, both civil and criminal court, RERA has to lodge a complaint with them. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which the authority or the adjudicating officer or the appellate tribunal is empowered by or under this Act to determine, and no injunction shall be granted by any court or any authority in respect of any action to be taken by in pursuance of any power conferred by the Act. In short, basically civil, criminal court, nobody, metropolitan, nobody has any authority. Only the flow of complaint can go from RERA to them, or they can at best direct people to go to RERA. A self-certification and self-discipline approach, Section 4, 1 and 2, read with 3 as given in Maharashtra RERA registration and development, registration of RERA agent and interest and disclosure on website 2017. If found guilty under Section 7, action will be taken. Then they will hand over the construction of work to an associated of persons, that is the allottees association, and if they can't do, then the RERA will take it to a group of other companies who are doing it. They have already started on this work, where regionally every place they have made groups of builders, and anybody defaulting, they will give the work to that person, that group. Section 8, that is they get control of the escrow account bank also. If any builder defaults, while first option is to give to AP, then to this group of people, and then also they'll also freeze the bank account. Friends, we have covered up offences and penalties, and you know what offences constitute and what is a title defect. It is expected that all adhere to sanction plans, and if they don't, you can lodge a complaint with RERA under Section 14. They cannot show you one plan, change it the next day. With this, I conclude today's video. So far we have already covered the background and objectives and other topics. So in the next video I shall talk about only revocation. Okay. Yeah, which is a very important one. Revocation is a very important topic. As I conclude, I once again request you to leave a comment, and if you have liked the video, please subscribe to it. Please also share it with other groups so everybody benefits from the information and knowledge. Thank you so much.